A police cruiser pulls in behind you. You glance in the rearview mirror. No lights, no siren, just a patrol car, matching your speed, following your turns, mile after mile after mile. And something in you knows this is not coincidence, but you do not know what to do about it. So you do what most drivers do. You keep driving. You grip the wheel a little tighter. You check your mirrors more than you should. You start second-guessing every lane change, every speed, every full stop at every sign, because you know he is watching and you do not want to give him a reason. What you do not know is that the reason may already be decided. A patrol car that follows you for 2 miles or more without initiating a stop is not passively observing traffic. It is running a sequence, a documented, trained procedure designed to generate the legal justification for a stop that did not exist when the following began. If nobody ever told you what that sequence looks like and exactly what to do when it starts, subscribe to this channel right now, because that is exactly what this video covers, and more videos are already on the way. Here is what you need to understand about a patrol car that follows you before anything else, because the way it feels from inside your vehicle and the way it functions as a legal procedure are two entirely different realities, and the gap between them is where your rights either get used or get abandoned. When an officer follows a vehicle without initiating a stop, the encounter is legally characterized as a consensual observation. No seizure has occurred. No detention has been declared. You are free to drive. The officer is free to observe. That is the baseline legal posture of the situation, and it sounds neutral until you understand what the observation period is actually being used for. Officers are trained in what some departments formally call a follow-to-develop procedure. The concept is straightforward. Maintain visual contact with a vehicle long enough to document a traffic violation that justifies an independent stop. A lane drift, a rolling stop, a failure to signal a lane change 3 seconds before the turn, a speed that ticks 2 miles per hour over the limit, traveling slightly too slowly in a manner that could be documented as impeding traffic. The list of observable infractions available to an officer following a vehicle for 2 or more miles on a normal road, in normal traffic, by a driver who is now hyper-aware of being watched and compensating nervously, is not short. It is comprehensive, and the stop that results from that sequence will not reference the following. The report will begin at the infraction. The 2 miles of observation that generated the opportunity to observe that infraction will not appear in the probable cause statement. You will never know it happened unless you already knew to look for it. The follow-to-develop sequence does not just produce a traffic infraction to justify the stop. It produces something more valuable to the officer's investigation, and it produces it before you ever roll down your window. Driving behavior under observation is not the same as normal driving behavior. Drivers who notice a patrol car following them alter their behavior in ways that are observable and documentable, ways that experienced officers are trained to recognize and record. Overcorrection, sudden rigidity in lane position, checking mirrors at intervals that are documentably higher than normal traffic behavior, speed modulation that does not correspond to traffic flow, delayed signaling that reflects distraction rather than intentional noncompliance, abrupt turns that suggest route avoidance. All of these behaviors are consistent with a driver who is simply nervous because a police car is behind them. All of these behaviors are also consistent, in an officer's report, with indicators of impairment, consciousness of guilt, or evasive driving. The same behavior that you experience as anxiety has a second interpretation that ends up in a probable cause statement. And the 2-mile following window gives the officer enough observation time to build that secondary narrative into something that looks, on paper, like an independent pattern of behavior that justified increased attention. What feels to you like being followed unfairly reads in a report as a driver who exhibited multiple pre-stop indicators before a lawful traffic stop was initiated. The follow is not passive. It is the first chapter of the case. Now here is what most drivers do when they realize they are being followed, and both responses damage them in different ways. The first driver panics and keeps driving as if nothing is happening. They are so focused on not giving the officer a reason to pull them over that they overcorrect everything, slowing below the limit, signaling excessively, coming to full complete stops that are slightly longer than normal, checking mirrors with a frequency that is itself observable. The irony is that the attempt to drive perfectly under observation is itself the observable behavior the officer is documenting. Perfect driving is not neutral. Perfect driving by a driver who has just noticed a patrol car is a behavioral pattern with its own interpretive value in a trained officer's observation record. The attempt to be invisible is not invisible. The second driver tries to lose the tail. They turn unnecessarily. They speed up to create distance. They make route choices that have no navigational logic. This is the most dangerous response, and not only because erratic driving generates the infraction the officer was following them to find. Evasive driving in the presence of a police vehicle is a documentable behavior that courts have recognized as a factor in reasonable suspicion analysis. In Illinois versus Wardlow, the Supreme Court held that flight from police in a high-crime area was a factor that contributed to reasonable suspicion. While Wardlow is a specific context and not a blanket authorization for flight equals guilt logic, it established the framework that courts use to evaluate evasive behavior as a component of suspicion. Trying to lose the tail is not just ineffective. It is evidence. Here is what the courts have established, and this is the part of this situation that almost nobody explains to you before you are in it. A patrol car following your vehicle without initiating a stop does not constitute a seizure under the Fourth Amendment. The Supreme Court addressed this directly in United States versus Mendenhall, establishing that a person is seized within the meaning of the Fourth Amendment only when, by means of physical force or a show of authority, their freedom of movement is restrained. A cruiser following you at a legal distance on a public road, without lights, without sirens, without any directive, does not meet that threshold. You have not been seized. The officer has not triggered the Fourth Amendment's protections yet. That means he does not yet need reasonable suspicion. He does not need to justify the following. He does not need to document why he chose your vehicle. He is observing a vehicle on a public road, and that observation is legally unrestricted. What this means practically is that you cannot challenge the following itself, because the following, legally speaking, did not happen to you. What you can challenge is everything that comes after. The stop. The stated basis for the stop. Whether the infraction documented during the follow was real, was observed in compliance with your state's vehicle code requirements, and was documented accurately. The following created the stop. The stop created the legal event you can contest, which means the most important thing you can do during the follow is not prevent the stop. It is make sure that when the stop happens, your behavior during the follow is not the second column of evidence in the officer's report. So here is exactly what you do. The moment you identify that a patrol car has been following you for more than 2 turns or more than a mile with no apparent independent purpose, you do 5 things in sequence, and each one matters. First, you pull over voluntarily, in a safe location, before he initiates the stop. Find a well-lit parking lot, a gas station, a commercial area with other people present. Use your signal. Pull in safely and completely. Stop the engine. This single action restructures the legal record of the encounter before it begins. You are no longer a driver who was followed and then pulled over. You are a driver who noticed a patrol car and proactively pulled into a safe, public location. The report begins differently. The body cam begins at a different moment. The narrative that was building during 2 miles of observation has to account for the fact that you did not run, did not evade, did not keep driving. You chose to stop, in a safe place, before he ever activated his lights. Second, if your dash cam is running, let it run. Do not turn it off. Do not reach for it. You have a First Amendment right to record law enforcement performing official duties in public, and that recording begins the moment the officer exits his vehicle. Third, hands visible on the steering wheel before he reaches your window. Fourth, when he approaches, before anything else, you say it calmly and without aggression. Officer, am I being detained, or am I free to go? Fifth, if he states a reason for the stop, you acknowledge it and say nothing further that is not legally required. You do not explain your route. You do not explain where you were going. You do not explain why you pulled over where you did. You pulled over because you noticed a patrol car and you pulled into a safe location. That is a lawful, responsible action. It is also the action of someone who is not running. The officer is going to approach this stop with the 2 miles of observation already in his mind, and you need to know how that shapes the conversation before you are sitting in that parking lot with his hand on your roof. He may open with, "Do you know why I pulled you over?" which is the standard opener designed to generate a statement before a reason is given. You did not pull him over you. You pulled yourself over. Officer, I pulled into this parking lot when I noticed your vehicle behind me. Am I being detained, or am I free to go? He may say, I've been following you because you were swerving back there. A stated infraction from the follow window. Officer, I wasn't aware of any swerving. Am I being detained, or am I free to go? You are not denying. You are not arguing. You are acknowledging his statement, declining to build on it, and returning to the one question that requires a legal declaration. He may say, I need to see your license and registration, without answering the detention question. In states with stop and identify statutes applicable to traffic stops, you produce your identification under that statutory requirement. You ask once more before producing, Officer, am I being detained? If he confirms detention, you comply. Everything beyond compliance is minimal and precise. He may tell you he smells alcohol or marijuana, a sensory observation that functions as probable cause for expanded investigation and is extraordinarily difficult to challenge in the moment. You do not confirm, deny, or elaborate. I prefer not to answer questions without my attorney present. That is the complete response to any probable cause assertion that invites you to provide additional information. You are not building this case with him. There is a layer of the follow-to-develop procedure that most legal content never addresses, and it is the layer that matters most once a stop moves into a search or an arrest. The 2-mile follow window almost never appears in the officer's probable cause statement. The report begins at the infraction, the lane drift, the rolling stop, the speed violation, and proceeds from there. The observation period that generated the opportunity to observe that infraction is background context at best and invisible at worst. What this means for your defense, if this stop escalates into charges, is that your attorney will need to reconstruct the full timeline of the encounter, and the evidence needed to do that reconstruction is precisely the evidence that disappears when dash cams are turned off, when drivers do not note the location where the following began, and when the details of the follow, what turns were made, what roads were covered, how many miles, are not documented anywhere except the officer's memory and your own. The moment you voluntarily pulled over, the moment you noted the location, the moment your dashcam recorded the approach, all of that is documentation. None of it was required. All of it is potentially exculpatory. Defense attorneys who handle traffic stop cases will tell you that the cases they can most effectively challenge are the ones where the client had footage, had a timeline, and had a record that predates the officer's report. The ones they cannot challenge are the ones where the client panicked, kept driving, eventually got pulled over, and handed over everything asked before a single question about the stop was on the record. Everything that happens during that follow and during that stop has the potential to end up in front of 12 strangers. That is not a hypothetical. It is the realistic endpoint of any traffic stop that escalates past a citation, and you will not know during the follow whether this is the kind of stop that escalates. The jury will not see the 2 miles of observation. They will see the body cam footage that begins when the officer exits his vehicle. They will see whether you were calm or agitated, whether your hands were visible or searching, whether you answered questions you had no obligation to answer, or whether you were precise and composed. They will see whether you pulled over voluntarily into a safe location or whether you kept driving until lights and a siren forced a stop. The drivers who come through that footage most protected are not the ones who argued about being followed. They are not the ones who tried to outrun the observation. They are the ones who recognized what was happening, made a deliberate choice to pull over before being ordered to, kept their hands visible, addressed the officer calmly and by title, and exercised their rights in a way that looked exactly like what it was, a knowing, informed response from someone who understood what was being done and responded to it correctly. The follow is the first chapter of the case. Make sure your behavior during it is not also the closing argument. Memorize these before you close this video. When you identify a patrol car following you for more than 2 turns or more than a mile, pull over voluntarily in a safe, well-lit, public location before lights or sirens initiate the stop. Signal. Pull in cleanly. Stop the engine. Let the dashcam run. Hands visible on the steering wheel. When the officer approaches, Officer, am I being detained, or am I free to go? If he states a basis for the stop, acknowledge it and say nothing further. I wasn't aware of that. Am I being detained, or am I free to go? If he asserts a sensory observation like smell, I prefer not to answer questions without my attorney present. If field sobriety testing is raised, Officer, I respectfully decline to perform any field sobriety tests. I am exercising my constitutional right to refuse. Am I free to go, or am I being detained? If you are placed under arrest, I want an attorney. For words, said clearly, said once, nothing else follows. Every one of these positions is backed by constitutional law and documented case precedent. None of them require aggression. None of them require argument. All of them work because they are specific, on the record, and they give the officer no unearned cooperation to construct a case from. This is educational content only and does not constitute legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your circumstances. If this video reached you before the next time you look in your rearview mirror and see a patrol car that does not leave, it did exactly what it was built to do. Subscribe to this channel right now, because understanding what a 2-mile tail actually is and what to do about it is one piece of a much larger picture. And every gap in your knowledge is a place where that follow becomes a stop, the stop becomes a search, and the search becomes something you are still dealing with 2 years from now. Every video on this channel is built around one scenario, one legal framework, and one set of exact words, so that when the moment comes, you are not guessing, you are not panicking, and there is nothing left to chance because you did not know it in time. Subscribe. Share this with everyone you know who drives, because someone watching this tonight may be in that rearview mirror situation tomorrow. Grip tightening, mirrors checking, no idea that pulling over voluntarily and saying 4 words was all that stood between them and the case that follows. Make sure they know their rights, how to use them, and how to walk away protected. Stay calm, stay protected, stay free.